Good afternoon. Thanks for joining today's webinar, U Nonimmigrant Visa and Status. I am Sofia Carreño, Communications Coordinator for CUNY Citizenship Now. We invite you to submit your questions related to today's topic to the questions box in the control panel at the right side of your screen. We'll address as many questions as possible during the Q&A session at the end of this seminar. If you experience technical difficulties throughout this webinar, please call 1-800-263-6317.
Today's seminar will be the last one of the series Selected Issues on Citizenship and Immigration Law. I want to take this opportunity to thank our sponsor, the CUNY School of Professional Studies, for their support of the series. SPS's experience with online education has been fundamental to the success of this series. Many of you have already expressed interest in their Immigration Law Status Advanced Graduate Certificate Program, and we invite you to learn more about it by visiting SPS's website, which is in the screen right now, I think. Many of CUNY's Citizenship Now staff members have obtained the certificate, and they agree that it has helped them with their professional development. I also want to invite you to visit CUNY Citizenship Now's website. Our webinar series is over, but opportunities to learn more about immigration are still available through our volunteer corps. For those of you who are not members yet, I'd like to invite you to visit our website. Our CUNY Citizenship Now application assistance events are a great opportunity to obtain hands-on experience on immigration and to network with people working in the field. Also, by becoming a member, you will start receiving our newsletter, Citizenship Now Monthly, and will have access to our member network. Now I'm going to leave you with Patricia Wonder. Patricia is an attorney and an instructor at the SPS Immigration Certificate Program, and she has been the moderator for our webinars and the person in charge of working with our guest speakers to develop the content of the series. On behalf of CUNY Citizenship Now and SPS, I'd like to thank Patricia for her leadership and for contributing her experience as an instructor throughout this series. Patricia, thanks, and I pass on the mic to you so that you can introduce today's speaker, Julie Dinerstein.
Thank you, Sophia. Can we have the next slide? So, welcome everyone, and we're talking about U Nonimmigrant Visa Status today, and I'd like to welcome and turn it over to our speaker, Julie Dinerstein, who is the co-director of Sanctuary for Families Immigration Intervention Project. Julie?
Hi. Thanks so much. I'm very excited to be here and to be part of a webinar. So why don't we go to the next slide and get started today. We're going to be talking about U visas and U Nonimmigrant Status. And we're going to the next slide to talk a little bit about what it's about. So U visas and U Nonimmigrant Status are really about two distinct things that work hand in hand. One is to encourage victims, immigrant victims of crimes and criminal activities, to be working with law enforcement and government officials. This is really a key part to keeping all of us safe here in America. And then the second thing is to really give law enforcement and other government agencies charged with investigating, prosecuting, and presiding over criminal activity way an opening into working with the immigrant world and making sure that everybody here stays safe. So let's go to the next slide. So the immigration status called U Nonimmigrant Status comes to U.S. law on October 28th of 2000 as part of the Victims of Trafficking and Violence Protection Act, which is within the Violence Against Women Act reauthorization. A lot of people think that U Nonimmigrant Status really speaks only to victims of domestic violence or other gendered crimes, but as we're going to talk about, it's actually a much broader provision that gives immigrant victims yet another reason to feel safe talking about the criminal activities that they've been victimized by, and another tool for law enforcement and other government agencies working with immigrant communities to ensure an open line of communication. Next slide. There are really two aspects of obtaining U Nonimmigrant Status or becoming eligible for it and applying for it. So the first level really is looking directly at the statute and the regulations, is a person who you might be working with, let's say your client, is that person eligible? We call this level 1. Are they a victim of a qualifying criminal activity? Have they cooperated with the government, the appropriate government agency? Have they gotten the right kind of certificate that they're going to need in order to apply for this status? So that's level 1, just looking basically, do they fit into the eligibility criteria? Then level 2, which is something familiar to immigration practitioners, is after you found out that your client does seem to fit in a category of eligibility, are there going to be reasons to bar their eligibility? Is there going to be some other reason why they're not going to be eligible for status? We call that level 2. A list of reasons why people might not be eligible for status are really categorized in what's called the grounds of inadmissibility, which are found at 212A of the Immigration and Nationality Act. But as we're going to see, in this particular kind of case, the U Nonimmigrant Status case, the waivers of ground of ineligibility are really very broad. So when we're talking about level 2 here, we are in a much better situation for somebody who is eligible for U status than really almost any other immigration status I can think of. I'm going to go to the next slide. So an overview of what we're looking for, and again, these are the 5 steps that I'm going to be breaking down. The overview is that a petitioner has suffered substantial physical or mental abuse as a result of being a victim of qualifying criminal activity. They have credible and reliable information about the criminal activity. They're able to get certification to establish that they have been, are being, or likely to be helpful to a law enforcement official, or I would add to the other appropriate government official who might be needed. The criminal activity has to be an activity that is prohibited under United States law. So generally that means a law that governs people who are physically present in the United States, but there are some criminal acts that take place outside the United States over which the U.S. government considers it has power. So, for example, certain terrorist acts abroad, certain sex crimes against children that occur abroad, but your hook is it has to be covered by U.S. law. So for the overwhelming majority of people, that is going to mean the actual criminal activity occurred here in the United States. It is covered by a law. And then finally, as we're going to go into more detail, your client is not inadmissible, or as we'll discuss, they're not eligible for a waiver. So again, that was really an overview, but I'm going to repeat it again here in a sort of a breakdown of 1 through 5 steps. So step 1 is you first have to know if your client is a victim of criminal activity. Sometimes wonder, what if they're a bystander of criminal activity? What if they have information about criminal activity? Well, that's going to be not enough. What you need is you need to be an actual victim, as that is defined in the statute and in more detail in the regulations. It could be a state law, a federal law, a local law, a tribal law, but your client must be the victim of the criminal activity. Second, has your client suffered? There are times when you meet victims of criminal activities and you ask if they've suffered in any way. And luckily for them, they actually did not suffer when they were victimized by that criminal activity. But that person then will not be eligible for this immigration status. The overwhelming majority of victims of criminal activity, oh sorry, we accidentally went to the wrong slide. We're still here on our 1 through 5. The overwhelming majority of victims of criminal activity, in fact, do suffer a great deal. That is the common situation of a victim of criminal activity, but it is not always true. So you need to be sure that there has been suffering in the case of your victimized clients. Next, are they cooperating with government authorities? Another big mistake that sometimes people make is they think that there is a way around a cooperation requirement, that this could be a one-way street, that a person victimized by criminal activity who has suffered greatly might be able to get around a cooperation requirement if there's a really good reason why they didn't cooperate. But in fact, that is not the case. For this particular immigration status, the U Nonimmigrant Status, you need to be a victim who is cooperating with the appropriate government authorities. The government authorities you need to cooperate with are going to be different in different situations. Maybe it's Child Protective Services. Maybe it's the district attorney. Maybe it's the police. It's going to change in different contexts. But you've got to be cooperating with the relevant authorities, and the basic requirement is that you've got to be helpful. Number 4, you must, and I can't emphasize enough, I underlined and bolded, you must have a required certification. As we'll learn, there's a specific form, Form I-918 Supplement B, which must be signed. If you do not have a government, the required government certification, you cannot apply for this status and you can't obtain it. There is no way around the certification. There are many local jurisdictions where local authorities or federal jurisdictions where government authorities refuse to provide the certification despite enormous cooperation. If you don't have that certification, you have nothing. So very important to realize that in the U Nonimmigrant Status case, there are other kinds of cases that are somewhat similar where there's a way to get around a certification requirement. Here, there is no way around it. And then 5, as we discussed, there's the inadmissibility question. Is your client inadmissible? And if yes, can it be waived? So those are your 5 steps. Let's go on to the next slide. So then step 1 is your client a victim of a qualifying criminal activity? Not all criminal activities in the universe are covered. There are a lot of very common ones. So some of those victims of criminal activity do have a gendered theme. There is domestic violence, sexual assault. Those have gendered themes, which makes sense. That comes in with for legislation that was enacted with the Violence Against Women Act. But then there's some kinds of criminal activities that are really unrelated to gender per se. One is a felony assault. Anyone can be a victim of a felony assault. And the other is manslaughter. And it's not only manslaughter, but murder. And so, of course, you always think, or I always think, well, what does the victim of manslaughter, victim of murder need with U.S. government officials? There are future travels, perhaps, but that wouldn't be the U.S. government for the government to decide. But as you see, it is not merely the victim. Clearly, a person who is now dead doesn't need immigration status, but a victim of an attempt or a victim of conspiracy is also going to be eligible for this kind of immigration status. What I want to caution you here, there's actually a list of qualifying activities, and you'll find it in the statute 101A15U. But what I want to caution you here is many people are aware of clients who've been victimized by some really horrible actions by notarios or bad lawyers, and they say, well, this person has been victimized by really horrific bad lawyering that has created a problem in their lives. And the answer, unfortunately, is those kinds of activities are not covered. So you want to make sure that you go on the list, but the victims of bad lawyering or the victims of notarios, non-lawyers messing up their lives, not going to be covered under this statute. Let's go to step 2. So step 2, suffering of substantial physical or mental abuse. The word abuse is the word in the statute, but it really means harm. And when you talk about the harm, you really don't have to have had your arm or your leg cut off to qualify for substantial harm. And you don't really want to look at other kinds of immigration law for looking at what constitutes substantial harm. This is really a world in and of itself, what constitutes substantial harm. So in this case, you have the nature of the injury that was inflicted or suffered, the severity of the conduct, the severity of the harm, the duration of the harm. This is where, and then the next one I want to point out, pattern of abuse by this perpetrator against the victim. So particularly where it's not a one-off crime like a stabbing or a shooting, but an intimate partner domestic violence crime or a parent-child crime where there's family violence ongoing, you can look at a pattern or practice of what might be considered low-level activity or a criminal act that comes to the attention of authorities that may be a relatively small act in the grand scheme of things, but you can look at outside the specific act that is being investigated or prosecuted or presided over by a judge, you can look at a pattern or practice. And this really gives you wide latitude, particularly in criminal activities committed against family members or people who know each other, to look at a wide pattern. You are also able to consider the pre-existing condition of your client. Did they have something about them that made them particularly vulnerable to this act? And the harm need not be physical. It can absolutely be mental. Let's go to step 3. Step 3, Has your client cooperated with the appropriate authorities, the investigating or prosecuting or presiding over authorities? These are questions you need to ask your client. Now, sometimes if you become aware that your client has been a victim of criminal activity during an ongoing investigation or prosecution, or while your client has recently become a victim of criminal activity and may not have initiated contact with the appropriate government agencies or may not have responded to it, that's a great time to step in and let your clients know that the importance of cooperating going forward is really it. If they choose not to cooperate, then that's really the end of the availability. Now, if a client comes to you and they were a victim of criminal activity in the past and any investigation or prosecution has come and gone and there is no opportunity for government involvement, then it's really too late. When you talk to your clients about cooperating, it's not only about being responsive to questions, telling the truth, making people available to testify. It can also come down to really small things. A lot of the people that I represent are very poor, for example, and they can't pay their cell phone bill. So clients are unable, so government authorities can't reach the client. Not that the client wouldn't be happy to talk to them, but simply because they don't have a reliable number where they can be reached. If you're working with a client at that stage of the game, you really want to help them. Find a way for them to pay a cell phone bill. Find a way for them to have a neighbor or somebody else who can relay messages quickly. Because without cooperation, you have no case. So that's the next point. Going on to step 4. So again, the cooperation is what is going to lead to a certification. And it's really cooperation around investigating or prosecuting or presiding over, if you're talking about a judge, in investigation or prosecution or presiding over criminal activities. It's very important, and I try to go through my materials as time goes on and really take out the word crime and put in the word criminal activities, because there are a lot of bad acts that violate a criminal law. So I practice in New York City. We have a pretty big New York penal law, which has a whole bunch of activities that are prohibited under our penal law, and those activities may be investigated by the police, may not lead to an arrest. Those activities may be investigated by Child Protective Services when they're carrying out their mission to investigate the welfare of children. Those activities that are violated in our penal law might come up in a family court trial where they're presiding over a family offense petition, where a family offense is by definition activities that involves, among other things, activities prohibited by our penal law. So it doesn't matter if there's an arrest, if there's a prosecution, if there's an acquittal, what the results of the investigation, prosecution, or presiding over of the activities, this review of the criminal activities are. You just need the government involved. The government, of course, has to believe that these criminal activities have occurred, and then the government has to be willing to sign off on this certification. If you have no certification, you have no case. So in New York City, where I practice, I'm going to tell you where we often get certifications. Our most common certifications are from the district attorney's office. New York City has 5 distinct district attorneys. We get certifications from them. We commonly, that would be our biggest supplier of certifications. After there's been some kind of criminal, after or during, depending on the district attorney's office, a criminal prosecution. We get a fair amount of certifications from Child Protective Services. They are not a law enforcement authority per se in a traditional sense of being a police or district attorney, but they are charged with investigating activities against children and investigating families where there is some threat to the children. So we often get certifications from them. In New York City, my understanding of the New York City Police Department's policy is they will certify in cases where there hasn't been an arrest that's been turned over to the district attorney's office. But my experience has been is that once there is arrest, there has been arrest, they generally ask you to go to the district attorney's office for certification. There are also now family court judges in New York City who will certify. So these are the most common players. I encourage all of you who might be helping clients work on these kinds of cases to make sure you know who the government players are in your community who might certify in an appropriate case, and also to be aware that there are a lot of government agencies throughout the country who choose not to certify even though they have the legal option to do so. There's not a requirement, and your client, as I said, may be cooperating enormously in the investigation or prosecution of a horrific crime of which they've been a victim, and yet not have a case because they don't have a certification. So this is the important point. No certification, no case. Next step. So actually, we're now going to take a minute here to talk about our poll question. So we're going to start out with our first client here, and this is Sandra. A few years ago, Sandra was raped. At the time, Sandra had been in the U.S. for a few months, and she did not want to tell the police. She did not speak any English, and she was afraid. She did talk to a counselor at a community center in her neighborhood a couple of months after the attack. She ended up spending 3 years in counseling. So let's consider the possible answers. Is she eligible for status? So the poll is now open, and I want to make sure that people know they can answer the poll, and I'm going to read aloud the questions as you are considering them. I see here on my screen that lots of people are actually now answering the poll. So the first question is she eligible for status? The answers are yes, because she was the victim of a rape. Yes, she's the victim of a rape, and she suffered emotional harm. Yes, she's a victim of a rape, she was harmed emotionally, and she received counseling. And then finally, no, because she did not report the crime to the police. So while you guys are voting, let's try to think about these different crimes. I see that we have about 50% voting so far, so would love to see the other 50% chime in. What do you do in this situation? What do you do if somebody reports to you today, as Sandra does, I was the victim of a rape. It took place a few years ago. My suffering's been enormous. I've been in counseling. There have really been some horrible, horrible things going on. Going to give it another about 20, 30 seconds, and then we're going to discuss the answers that we have here. And I want to tell you, this is not an uncommon situation. Many people are crime victims. I wish that weren't the case, but many people in our day-to-day lives, in our communities, are victims of criminal activity. And there's some crimes that people don't like to report, like rape. I'd say that's true for U.S. citizens as well as immigrants. And then there are some people, like immigrants in general, who are afraid, either because of their language, lack of familiarity with the government system, or fear that they are going to be, that they're somehow going to get in immigration trouble if they talk about a crime that is unrelated to their actual immigration situation. In this case, she was raped. So I think we're going to go ahead and look at the answer to the poll. So can we close the poll? Okay. So now we're going to share with you the results. And I say 3% of you said yes because she was the victim of a sexual assault or rape. 14% say yes, she is the victim of a rape and she suffered. 11% said she's the victim of the rape, she suffered emotional harm, and she got counseling. And over 70% of you say no, she did not report the crime. And I'm going to go with the 70% of you. In this case, she did not report the crime, and that's really going to be a problem. Now, that's true most of the time, but I want to say, let's say she'd been 14 or 15 when she comes to you. So she was raped when she was 10, and she comes to you at 13 or 14 or 15. Is there going to be an investigation started? Well, maybe Child Protective Services might investigate whether she was raped and whether she had adequate supervision. So there is a slight chance that if you could initiate a government investigation a few years after the fact of the crime, that there still might be an eligibility for immigration status. And I'd say particularly with children, there have been opportunities to report crimes maybe several years after the fact, and Child Protective Services will often want to know about criminal activities that occurred against children if those people remain children, because Child Protective Services will want to investigate the well-being of those children. So it's important to say you need government involvement, but on the facts we have here, there is no criminal report. So now we're going to go on to step 5, inadmissibility. So let's say you have your client who is suffered as a victim of criminal activity. They have cooperated with the appropriate government agency, and they have suffered, and you have your certificate. Are you free and clear? Are you ready to go? No. There's one last step you're going to have to look at before you're going to decide, is this person likely to be eligible for this immigration status? Is this appropriate? And we're going to go through and we look at 212A of the Immigration Nationality Act, and that looks at grounds of inadmissibility. Is the person inadmissible? And there's a really long list. It goes on for several pages or several computer screens. So we're not going to look at it together today, but just know that there's a long list of reasons why someone may not be eligible, even though they met all the criteria. And the good news, particularly, and you'll find this very good news if you don't practice in another, if you are familiar with immigration practice generally, is there are very, very few things that cannot be waived as a technical matter. The only grounds of inadmissibility that can't be waived are 212A3E. And who comes within 212A3E? And I'll go through it. It's I know it by heart, and it is not a group that I've ever had to deal with. So one, people who were card-carrying members of the Nazi Party in the 30s and 40s in Germany and occupied and the other countries affected by World War II. Haven't run into anyone like that. Somebody who's committed extrajudicial killing, somebody who's committed genocide, and somebody who's committed torture. If you've done one of those 4 things, you cannot waive the grounds of inadmissibility. But everything else, technically under law, is going to be waivable. There is discretion to waive it. The actual law that covers this point is Immigration Nationality Act 212D14. You'll see it's there are very few words in that provision, and it's very broad. Though in the regulations, 8 CFR 212.17, you'll find out that the Department of Homeland Security says, you know what, it may be technically possible to waive in a broad array of grounds of inadmissibility, but when there are really serious problems here, we're not going to waive it. And just from experience, we're talking generally about violent crimes that result in a year or more of incarceration and drug crimes. Those are the 2 kinds of criminal activities that they're least likely to want to waive. Let's go to the next slide. So as I pointed out in the last one, we're talking about the last slide, the rules are really quite broad. Really anybody can come in under this waiver. It's a broad language around public interest and a long set of discussions around a public interest and family unity. So when we're thinking about preparing our waiver, which we file on Form I-192, we really try to think about, is there harm to society? If there is possible harm to society, what indications do we have of rehabilitation? How serious were the criminal activities? And why does the applicant need to apply for non-immigrant status right now? How compelling is it? I can tell you we have had clients who have relatively few equities, single adults without children, without other family members, who are just here in the United States and building their lives here. And we've been successful on Form I-192. So you don't have to go crazy on your equities. Where you have them, you certainly want to provide that information in connection with your waiver of inadmissibility, but it's waiver of inadmissibility application, but it's really much less stringent than a lot of other kinds of cases that you see in immigration. We're going to talk in the next slide about, oh, I'm sorry, before we get there, we're going to have one more poll question, and then we're going to talk about a particular subset of inadmissibility. So let's talk about this poll question, which involves Jesse. Jesse entered the United States in 2007 on a student visa, but he stopped going to school a couple of years ago when he could no longer afford the tuition. He has been working as an independent graphic designer in Williamsburg and making reasonable money since then. Doesn't sound like he's authorized to work, he's just working independently. One night, he is mugged and he ends up getting stabbed. A passerby calls 911, and Jesse's taken to the hospital and released the next day. So we're going to think about it. Is Jesse eligible to apply for U Nonimmigrant Status? So we're going to open up the poll. Last time we got 67% participation. Let's try to get it higher this time. And now let's go over the answers. So the answers are, no, he's not eligible because he stopped going to school after entering on a U visa. No, he's not eligible because he's worked without authorization. Or yes, he is eligible as long as he cooperates with the police. Or D, none of the above. Let's think about, take a few moments to think about Jesse and his Williamsburg mugging. I wonder, do we have anyone, I wonder if we have anyone on the webinar today to see how likely it is that you will be mugged in Williamsburg. So we're going to think about this. This is, again, actually quite a typical situation. Somebody may be living here, maybe they entered lawfully into the United States, but it is certainly possible that they, after entry, they start out without any immigration violations, but then they run into some immigration violations. They do things they're not supposed to. They don't meet the terms of in which they were admitted. They don't go to school. They work without permission. They overstay their period of authorized stay. We don't know exactly what his situation is, but very common. And then he ends up being victim of a criminal act. Again, not uncommon, as our mayor says, where our crime rate is down, but this could happen in New York City. This could really happen anywhere in America. You could be a victim of a criminal act. And what are your options? So I'm going to give folks maybe about 10 more seconds, 15 more seconds, and then we're going to close. I see we already have 71% voted. Get our last few votes in. We're doing better than our last poll. And we see 74%. This is great. And so we see a lot of people answering. So nobody thinks that not going to school is going to create a problem for him. Now, it might create an immigration problem for him, but it's really not going to create a problem for him in the U Nonimmigrant Status. No, because he worked without authorization. So technically not a ground of inadmissibility at all, but you don't have the list in front of you. But whether it is a ground of inadmissibility or not, just because he violated an immigration rule, whether it's not going to school as he was supposed to do, whether it's not, whether it's working, which he's not supposed to do, or whether it's something he's done under the exact list of 212A. But then the one option is yes, and this is the third answer, and I'd say 74% of you, I think you can see, said yes as long as he cooperates with the police. And that's pretty much true. As long as he's cooperating with the police, and then if an arrest is made with any other government authorities, for example, the district attorney's office, if required, complies with any orders of the criminal court judge, as long as he continues to cooperate, he is going to be eligible for immigration status. And then 20%, none of the above. I'm wondering where that none of the above came from. I'm wondering if you just think we don't quite have enough information yet. But as long as the cooperation goes on, then yes, he is going to be eligible as a victim of a felony-level assault who's cooperating with the appropriate authorities. Okay, we're going to move on to our discussion of this subset of grounds of inadmissibility, which is passport. And I just want to make a couple of points about it. Having a lack of passport. Most adults in the United States or in their home countries are able to get passports. Not all adults, but the overwhelming majority of adults, regardless of whether they violated any immigration rules here in the United States, can go to their own consulates and get passports. Here in New York City, not all countries, but a really substantial portion of countries have consulates here, and clients can go and get passports. Where we find our biggest problem in the work that I do is that many children cannot obtain passports if they are separated from either an abusive or a missing parent, because generally most countries will only give passports with the permission of both parents. So in this situation, in the situation of children, sometimes they can't get a passport. And there are really 2 points I want to make about this lack. One is if you're in the United States and you don't have a passport, that's a ground of inadmissibility, and you've got to apply for a waiver. If you can't get a passport, you must file the Form I-192 and apply for a waiver of inadmissibility if you don't have one. If you're outside the United States, in addition to applying for a waiver of inadmissibility on Form I-192, you really need a specific form, and that's called Form I-193, which is a separate additional form where you say, I'm looking for a substitute for my travel document. I'm filing this paper as a documentary substitute. Unfortunately, we have had very poor experiences having the I-193 adjudicated, and I can't think of a consulate in the world who's adjudicated an I-193 for somebody applying for U Nonimmigrant Status. We've had a few people who've been successful filing I-193s at the border and having those adjudicated, but none at a land crossing border, but none at consulates. So just so you know, those are the procedures. What happens on the ground is really a moving target, but I just wanted to take a moment and mention this. We're now going to go to our next slide. So the great thing about U Nonimmigrant Status, or there's so many great things, is that you can really join up with a whole bunch of family members, really many more family members than in most immigration types. You can, if you are 20 or younger on the date that you file, you can bring a large number of your family members with you. So that is a U2 for a spouse, any unmarried children under 21. So if you're 20 or younger, presumably so are your children, and unmarried, they can come in. Your unmarried siblings who are 17 or younger on the date on which you apply for immigration status. So this is a great way to bring in the parents, the spouse, the children, the siblings, bring in large numbers of family members, which is a great thing. A lot of people can come in. If the petitioner is 21 or older, then they can bring in just their spouse and their unmarried children under 21. This derivative status is granted only after the U1, the primary principal crime victim, is granted status. And the request can be made simultaneously, or it can be made, the request for the derivative family members, which is made on I-918 Supplement A, it can be made afterwards. So either you file the request for the family members at the same time or afterwards. A caveat, it can't be an after acquired family member. So for example, if you marry after you file your 918, you can't bring your spouse in. You can only, in this way, you can only bring your spouse in if you are married but don't file the physical form, Supplement A, at the same time. Then you can file it later on. In terms of date freezing, because I say the person is 20 on the date of filing or 21 on the date of filing, or people are unmarried and under 21 on the date of filing, there's actually a lot of litigation going on as to how long the relevant child needs to stay under 21. So right now we don't have a clear answer on derivative family members who turn 21 at some point in the process, and that is something to watch and to be looking for on listservs and to be watching litigation. There's some cases at the AAO, Administrative Appeals Unit, something to be looking for, so stay tuned on the issue of ages for qualifying family members who turn 21 at what point in the process. Let's go to the next slide and talk about an obvious exemption. You cannot bring in the family member who actually committed the qualifying criminal activity. If I'm married, my husband has no status, I have no status, I can't say to my husband, hey, let me stab you lightly on the arm, I'll go to anger management class, I won't get in that much trouble, and then, you know, you'll petition for status, I'll come in as your spouse. No, no, no. If I stab my husband, then he can get immigration status, but I cannot. So it's kind of an obvious point, but there's a specific regulation that makes that obvious point. Next slide. So what are the evidentiary standards with this kind of immigration relief? So the evidentiary standard is great. It's any credible evidence. As I said, you must have your certification. So the any credible evidence means in addition to your certification, you can submit anything you want. You can have, you know, drawings that your children submit that look like they're very disturbed or unhappy. You can have unsworn letters. You can take screenshots off the internet. You can, you know, have some way of conveying text messages that were sent, newspaper articles. You don't have any really challenging rules of evidence. You can really throw in anything that you want in the application that you're going to be filing with the federal government. Also, it's not an exclusive form of relief. You might have a client who's applying for maybe they're applying for asylum, or maybe they're being sponsored by their employer, or maybe they have a family-based immigration case, not from the abusive family member, but let's say somebody else, or even, I guess, technically from the abusive family member. It wouldn't be a bar. They could have some other form of relief going on. That's okay. Ultimately, you're going to go with the best immigration status you can get. A person who gets U status has to wait a while, as we'll talk about, before they can apply for a green card, but it's non-exclusive relief. Very interestingly and importantly, this is a relief you can apply for even if your client has a final removal, deportation, or exclusion order. Even if they do, you still file for with USCIS for this immigration status. You don't have to go back and get this old order removed, which is great. There is unfortunately a quota. It's at about 10,000. It's not about. It's 10,000 a year, though I will say I just looked at the statistics. I think they did give this immigration status to 10,073 people last year, so maybe about is the right word. It's supposed to be capped at 10,000. And it doesn't include all the family members, but just the primaries. Now, what do you say? What happens if somebody is eligible for this status, but they've already gone to 10,000 in the fiscal year, and the federal fiscal year, of course, ends September 30th? The answer to that is if the quota is exceeded, the petitioners are going to be placed on a waiting list and given deferred action. So somebody who is eligible for this status, but for the fact that they ran out of numbers, is given deferred action. That's a kind of immigration status that's going to let them live and work in the United States. They can apply for work authorization, and they stay on a waiting list till the beginning of the next fiscal year in October. Last year, they reached the 10,000 cap right around this time in the middle of July. This year, officials have informally announced they expect to reach the cap sometime in September, and then the new fiscal year begins in October 1st. So not really a worry. You can apply for this immigration status throughout the year, and if the government's run out of numbers, your client will get deferred action, and then the following year on October 1st, they'll be granted this status. Let's go to the next slide. How does this status work? The status works for 4 years. You're granted U Nonimmigrant Status. That's both you and your children or spouse or parents or siblings, depending on who your derivatives are, may be granted status for it should be 4 years. Now, we are, as I mentioned in a previous slide, seeing that people who are going to turn 21 at some point during their 4 years of status, children, that is, children who are turning 21, or siblings in some cases who are turning 21, are being given less than 4 years of status when they get their approval notice, their grant of U3 status or U5 status. We are encouraging people to file appeals. Working with pro bono attorneys, we are filing several appeals, and the form you use is 290B. You have 33 days from the date on the notice to file an appeal, and we are filing a lot of appeals. Not the subject of this webinar, but we encourage people to be on the lookout and think about this. Next slide. So a person, in addition to having the status for up to 4 years, and if I haven't made clear before, having work authorization during these 4 years, the real bonus is at the end of this temporary period of U Nonimmigrant Status, they get to apply in their final year of the 4-year grant of status, they get to apply for lawful permanent residence, which, as we know, is the big fancy phrase for green card. They get to apply to live here permanently. They are people who have to have been physically present for at least 3 years, which means for your average person, that's a 4-year grant of status, and in the final year, they have a 1-year window during which they can apply for a green card. The grant of a green card has to be necessary based on humanitarian reasons to ensure family unity or in the public interest. And really, that is really established usually by a statement where your client says that they would like to stay here for whatever reasons they do, positive reasons about staying here. There can't be an affirmative finding that your client has unreasonably withheld assistance from law enforcement or the appropriate government agency. You can usually satisfy that requirement with a simple statement from your client explaining their cooperation. And the person with U status cannot have been out of the country in total for more than 180 days or at any point for 90 days. And I just want to say, the reason I emphasize that we're talking about immigration status, U Nonimmigrant Status, and not U visa, is your client does not, when they have an approval of U status, does not in the United States get a visa. They leave the country, and their eligibility to get a visa to return, it may be compromised, may be complicated, and they may not be able to get a visa to return in 90 days or even 180. And if somebody's out of the country for more than 90 days in a row or out more than 180 days total, they are going to be cut off from eligibility from from getting a green card. So just something to keep in mind. We tell our clients not to travel until they become lawful permanent residents. Next slide. So I want to talk about what a typical case might look like. So we're going to start out with your principal petitioner. So the form you're going to be filling out is Form 918. There used to be a charge for this form. Now it's free. So you could be representing a very wealthy person who has lots of money. Doesn't matter, poor or wealthy, there is no fee for this form. You are going to have, as your first exhibit, I-918 Supplement B. This is a form, and I don't think I've made this point clearly, that not only has to be signed by the appropriate government official, but needs to have been signed within the last 6 months prior to your filing. So the Supplement B, signed Supplement B, is only good for 6 months. You're going to file it with a notice of appearance on Form G28, which goes on blue paper. You'll probably put together an index of the supporting documents. There are typically 2 affidavits we suggest people file, and those are, as you'll see when you have a chance to look at Form 918, it's a very long form, and your client is likely to answer yes to a bunch of the questions on the form. And we usually just have a separate affidavit which goes over all the responses to the form. And then your client or someone as a stand-in for your client is going to have to put together an affidavit or some kind of statement describing the harm that they have suffered. And then you want to index any other documents, maybe police reports, medical records, counselor statements, whatever else might be relevant to your case. In addition, for your primary petitioner, if your client is subject to a ground of inadmissibility, as we discussed, they would be submitting a Form I-192. The fee for this form is now $585. It went up at the end of November, but you can also apply for a fee waiver request. Because the I-192 may end up in a different part of the office from the 918, we suggest a second notice of appearance on Form G28, and that goes on blue paper. And then, depending on the ground of inadmissibility, our supporting evidence is usually simply an affidavit addressing the reasons why someone may be inadmissible and any hardship they must suffer, any equities. Next slide. Our derivatives, any derivatives that you're going to be filing for, are going to have a Form I-918 Supplement B. If, and there's sort of 2 requirements here, if the person is in the United States who's a derivative family member and they're 14 or over, and both things have to be true, then they are required to sign the Supplement A. If they're out of the country or if they're 13 or younger, they are not required to file that form. It's as simple as that. Then there's going to be an affidavit that you would probably want to file with your yes answers to any questions on Supplement A, and that can either be the petitioner, the main criminal victim who's bringing along a family member, or the family member themselves. It's usually a question of convenience who you have handy to answer to sign a supporting affidavit. Again, your derivatives may be subject to inadmissibility as well. So again, they're going to file that fee. It's $585 or fee waiver. You have a separate notice of appearance on Form G28, an affidavit, if appropriate, about the ground of inadmissibility and any problems. And if they're 14 or over, it must be signed by them. And that is true. If you're outside the country, you've got to get that Form I-192 to them. Then finally, there is the Form I-765. A person filing the 918, the primary petitioner, is going to get a work permit automatically if they're in the United States and they check off a box on the form saying they're in the U.S. and they'd like a work permit. In contrast, any family member is going to have to file a separate work permit application, and that work permit application is going to be on Form I-765. They can pay for it, or they can file a fee waiver request. We suggest they file a notice of appearance on Form G28, a separate one, because that's going to again go to a different part of the office. I would say list your office address for question number 3. What is their address? And the reason code that you're going to fill out on the form for a derivative family member is A20. Work permits are only for people in the U.S. Next slide. We're now going to try to quickly walk through the forms, and this is going to be a little bit more quickly than we've been going through the other slides. We just want to highlight some of the issues. I work with a lot of volunteer attorneys who are new to these cases. Some of the issues that come up for people. We like to get a client's safe mailing address on the form simply because they use that zip code for fingerprinting, where they're going to send your client for a fingerprinting notice, but otherwise everything's going to go to, and no mail will be sent to the safe mailing. No mail is going to be sent to their actual address, and we generally list the office as the safe mailing address. And as a general practice, everything is going to go to your office. The only point of listing their address at all is simply to give the zip code of residence for their fingerprinting. I have a few suggestions, and we're just going to flip through questions where that come up. So we're going to go, here's a slide, go to the next slide, which talks about some of page 1, some of the questions that come up, mistakes I see that are commonly made. Next slide. Page 2. The only thing I want to caution you here with respect to this is there's a question on this page about having been ordered, removed, deported, etc. If your client has crossed a border and been picked up, you want to stop and question them about what exactly happened when they were picked up. And for some clients, many clients in fact, it's hard to know if there's an official order or not, and it may be hard to get your hands on it. So I often write unclear, and then in a supporting affidavit provide information about their attempts to cross unlawfully, any encounters they've had with immigration officials, and what happened. And then saying you don't really know if proceedings were started or an order was issued. Next page. Here on page 3, I want to really caution you. As I said, you can get really, really, really broad waivers here. If you've committed crimes, you haven't been arrested for them. If you have been arrested for criminal acts, a lot of clients, if they're stopped by police and they think the record went away, or they think they were told the record was dismissed, or the event happened in a foreign country, people will just say no. You want to stop. This is really the great opportunity that your client has to disclose a use of a Social Security number that's not their own, arrest for turnstile jumping, being in the park after midnight, perhaps some drug arrests in the distant past. They've got to disclose it because it's asked, and they can get it waived. So there's a very important time to get that information out there, disclose it, and get it waived. I would also say that with any issue around disclosing criminal information, there is, as I always tell my students, there's really only 2 opportunities you have with respect to criminal law and immigration and the overlap. You must either, at the end of the day, before you file anything with immigration, you must be an expert or you must consult an expert. There's really no other way around it. While there's a great waiver available when your client has criminal convictions or other interactions with the criminal justice system as a suspect, you really need to figure out what those ramifications are going to be. And you see on your screen a great resource, the Immigrant Defense Project. They have a lot of great information. They have open telephone hours. They'll talk to anyone, and you really want to be careful about reviewing those issues. Going on to page 4, we are just highlighting page 4. We can go again at page 5. I mean the next screen, page 6. Next screen, page 6. There are a lot of questions, and we just go over here and highlight in the webinar some of the questions that really come up where people think that this can't be what they mean, or do I answer yes here? Some of the questions are so outrageous that your eyes tend to glaze over. Make sure you read each and every question, and I highlight here in these slides some of the questions that come up where we see a lot of confusion. Next slide. Again, I see sometimes a lot of people not listing all of their children, thinking it only means non-U.S. citizen children, or only children under 18, or only children in the U.S. Really make sure the demographic information that you get it right. Next slide. I want to talk about the Supplement A. Again, as I've mentioned before, the Supplement A, which is the form you use for derivatives, only needs to be signed by the derivative if they're 14 or over and in the United States. And testifying to or giving information, supplementary information affidavit, so the responses can be given by the petitioner, the 918 petitioner, or the derivative family member. Next slide. The Form I-192, we give examples of our suggested answers to all of the questions here and some suggested responses. When you read the form, you can tell that it's predominantly meant for people who are physically outside the United States, so a lot of the questions don't make sense. So we provide some suggestions as to the answers you might want to give to these forms. Next slide. Supporting evidence. I would say don't spend too much time on this for starters. If there are only a few grounds of inadmissibility that don't really suggest harm or danger to society, person entered unlawfully, the person doesn't have a passport, I think you can just say that alone without any real supporting affidavit if it's a very small ground or very small bad thing that doesn't seem to harm anyone actively. For non-drug, non-violent offenses, we are usually just having our client prepare a statement, a couple of pages. We work with the client to prepare. I would say one area to be wary of is in the mental health ground. They will sometimes ask for a statement from a mental health professional, and we've increasingly seen, if you are disclosing a mental health ground, that you may be asked to file a medical. So the standard medical on Form I-693 from an immigration civil surgeon. So just something to look out for. You could get a request for evidence. The only areas where we'd suggest that you really, really need to go to town and put a lot of effort in are the drug offenses and the violent crimes. I'd say USCIS is very, very reluctant here to grant waivers, even though they can. And so this is really where you want a book of reasons, a book full of reasons why your client should be granted a waiver. And so this is where you're going to find a hard time. Next slide. As I said, the primary U petitioner filling out Form I-918, they are going to have, they get work permits automatically, so they don't even need to file this application. For derivatives, you're going to need to file the application. You can only file it once people are in the U.S., and we do suggest filing it for everyone regardless of whether they're going to work or not. So if you have a 3-month-old, you file it for them because this is really going to lead to an identity document, ability to get a Social Security number. If you have a 97-year-old derivative, file a 765 for them. The age doesn't matter. The intent to work doesn't matter. This is going to be your one document, so file a 765. Next slide. As we mentioned, the I-193 is the substitute for a travel document when you are outside the United States. We are suggesting that people file it in Vermont. It can be filed with a fee waiver. We are not really seeing movement at the consulates with the Form I-193. We have seen success with I-193s being adjudicated at the land border. Again, somebody without a passport will also need an I-192 for the ground of inadmissibility. Next slide. And then we would suggest, because the applications get sliced and diced and the different forms go to different parts of the office, once your application hits USCIS, and though we don't have it on here, you'll find it in the forms themselves. In the directions, all of these forms are going to USCIS in a special office in Vermont. We suggest filing G28s on blue paper with each distinct number type of form. So the 918, the I-192, the I-193, the I-765, we would suggest notices of appearances on blue paper. So that can be a lot of blue paper. Next slide. And so there we are. And I think we're now open to questions. So Patricia?
Yes, thank you so much, Julie, for that thorough presentation. And we're going to start answering some questions now. Julie is graciously going to be answering your questions. I'm going to give her a minute to go over some of the questions that we've had. Our first question, Julie, I'll read it, and then you can just take over from here.
Okay, great.
But the first question is regarding when someone's in removal proceedings or if they've had a removal order. Can you just talk about in that scenario, what is the person, can they apply for U visa? Are they eligible?
How does that work? Okay, those are some really great questions, removal proceedings. So the answer is absolutely. You can have an old order or you can have a current case going on. Either way, there's one and only one office that adjudicates these cases, the U Nonimmigrant Status Petition, the 918, and that would be an office in Vermont, a division of USCIS. So the court doesn't have jurisdiction over it. ICE doesn't have jurisdiction. So whether you're in the U.S. with a removal order or somebody outside the U.S. with a removal order, they can file a 918, and if you're in removal proceedings, you can file a 918. There are some good memos. I don't know if we can later on put up links to them or not, but I will tell you when they are. There are memos dated September 24th, 2009, and September 25th, 2009. These are two memos, and I believe they're both put out by ICE, Immigration and Customs Enforcement. And with both of these memos, it says that if your client has an old order, the ICE prosecuting authorities are supposed to work with you in considering a stay. And if your client is currently in removal proceedings and has a pending case 918, the ICE should consider either administratively closing proceedings or terminating proceedings. Our experience is we haven't seen any terminations based on a pending U, although that's a possibility in these memos that are mentioned, that the memos mention. But we have, in our jurisdiction, have been successful with these memos in at least getting continuances. Sometimes administrative closure, and at a minimum, continuance. One of the things that can be done is that if ICE is considering your request for a stay of removal, if there's an old order, or considering your request for continuance or administrative closure, if there's a current deportation, current removal case would usually be the situation, you can the ICE official on the ground, your local ICE person, whether it's an attorney or whether it's a enforcement agent, can communicate directly with USCIS in Vermont, and USCIS will issue what's called a prima facie determination. The interesting thing about these prima facie determinations is that you, the lawyer, or you, the client, will never get it. We don't get a piece of paper that says prima facie determination. However, USCIS and ICE can communicate with each other, and USCIS in Vermont can issue a prima facie determination, which is usually what ICE, in our experience, is required before they'll consider a stay or before they'll consider a continuance or an administrative closure. I mean, continuances in the New York area are actually not hard to get, but certainly before they'll consider administrative closure. We've also seen some ICE officers, when there's a pending 918 with a prima facie determination, who've been willing to consider a deferred action request in that context. So the answer is very good news. Here's a great remedy for a client who has an old order or for a client who's currently in removal proceedings. Patricia, what do you think the next question should be that we might want to consider, or do you think there are other questions people might have that haven't been answered?
Yeah, let's answer, this is the second question. Do you have any tips or advice for clients who have difficulty cooperating or cannot cooperate with authorities because of the trauma they've suffered?
So this is a really tough situation, because I have had that situation before, and I think if a lot of us who work with criminal victims, victims of criminal activity, not the criminals themselves, but the victims, there can be crimes that are so horrific that people cannot cooperate. So, but some cooperation has to happen. So sometimes that can be with the children. With anyone who is under 16, it can be the parent or guardian or next friend who can be doing the cooperation. So there's a pretty straightforward out when you have children involved, people under 16 at the time of the criminal act takes place. There is also an exception for people who are incapacitated. So if you can get some kind of incapacitation argument, and somebody else can be a stand-in for the cooperator, then that is something that you can do. But somebody somewhere has got to be cooperating with the government officials. And if there's no stand-in, so for example, maybe a social worker at a rape crisis center can be working, providing the cooperation with authorities, or maybe a rape survivor could have a rape kit which is handed over to the government authorities, even if they can't speak about the act. And then as a sort of general matter, when people are suffering from trauma, I think it's always a really important idea to bring in mental health professionals when you can. But at the end of the day, if there is no cooperation, if there's not ongoing cooperation with the appropriate government authority, you have no case. So for some people, their trauma may be so great and their inability to connect with the government authority is so great that you have no case. And then that's really an unfortunate situation, but that's how the U works. No cooperation, no case.
Thanks, Julie. So we have another question. Is there a time limit for when the crime occurred and or was reported for applying for a U visa status?
There are no time limits involved. If someone was a victim of criminal activity in 1912 and you found a government agency who has a record of their cooperation with the investigation or prosecution, you can submit it now. It could be 1812. It really doesn't matter when the criminal activity happened. You're going to always need the government certification, so it can be a question of records. We submitted a case involving, we've done a couple of recent cases where we had criminal activity that occurred in the early 1990s, and one of them was actually a double murder homicide that occurred in the 1990s. And we had two different certifiers, two different government agencies, and we were able, over time, we were able to get the records. It took a while for people to get records, early 90s. Some of you may be too young to remember back in the day before computers, but before there were computers widespread, a lot of records are hard to find. But if somebody can find the record and somebody can certify your I-918 Supplement B, that's okay. Your next question is, if the crime occurred 3 years ago, for example, Sandra was raped a few years ago, if the crime occurred 4 years ago or 10 years ago or 20 years ago, and the investigation is happening now or the report is being made today, is that okay? From the point of view of U Nonimmigrant Status law, that's absolutely fine. If you have a criminal act that took place 20 years ago and only now do you have a report to government authorities or only now do you have an investigation, as long as the government will certify, you're fine. But I think that you'll find outside of a few case types, for example, sexual assault of children or murders that were not discovered that were previously misclassified as accidental deaths or that weren't previously investigated. There are very few criminal activities that government officials are going to investigate as time goes on. Sometimes it's a question of statute of limitations. Often, even when the statute of limitations hasn't run, government officials, regardless of their specific act, whether they're investigating or whether they're prosecuting or whether they're presiding over, they're going to be focusing on the criminal acts and criminal activities that are taking place right now or relatively contemporaneous. So from an immigration perspective, no time limits at all. From a practical perspective, if the act and the cooperation took time a long time ago, it's just coming up, getting someone to find the records, not always possible. And if the act occurred a long time ago, but you're only involving government officials now, you may not find any government officials with the opportunity to investigate or prosecute those activities just because they're busy with current or recent criminal activities. So that's the answer to that one.
Okay. So we have one more, Julie. It's the last question. Can you explain the difference between a U and a T visa?
Sure. So the U and T come into being. They come into an existence at the same time. They're right next to each other, 101A15U and 101A15T. And there's a lot about them that's similar. With respect to both cases, you're talking about people who are victims of criminal activities. With respect to both cases, the idea behind the legislation is to make sure that victims of criminal acts are cooperating with government, government's cooperating with victims of criminal acts. And with both of them, the idea is it's a temporary status that you and your family members can get in the short term, and over the long term that you'll eventually have the opportunity to apply for lawful permanent residence. You know, we could certainly do a point-by-point, 2-hour discussion of all the intricate differences, but I'm going to try to hit some highlights that come up. So a victim of a trafficking criminal act can actually apply for either a U or a T. So the actual victims of trafficking, whether it's sex trafficking or labor trafficking, have the option to go either route, the U route or the T route. For the U, you need to be a victim of just trafficking, and for the T, you need to be a victim of they have a very funny phrase about it. Substantial and serious trafficking, or some like extra really bad trafficking, which is kind of odd. I can't imagine like what trafficking would be like. But they have qualifiers on the severity of the trafficking, and you must currently be present in the U.S. on account of that trafficking. So there are some differences right there, that the trafficking has to be extra special trafficking, and you have to be in the U.S. Going on from there, the cooperation requirement is higher for people who are 18 and over. It's a more detailed discussion of what kind of cooperation you have to have with the government. However, there's a blanket exception to getting to cooperating. So either you have to meet a higher level of cooperation with the government, and you get a certification from the government of a relatively higher level of cooperation, or there's a route where you don't need the cooperation at all. So that is a different, so there's an exception for people who are too traumatized, or maybe the government is choosing not to investigate or prosecute their acts of trafficking. So that can be very important for people who are not working with the government on a trafficking case. There are much better, on the plus side with a T, there's much better access to public benefits. So for people who are going to need to access a lot of federally funded benefits, they're going to do much better with a T than on the U. And while both the U and T, the sort of default rule is that you will have to have that immigration status for at least 3 years before you file for a green card, with somebody with a T, if they can get a certification from a federal official, not a state official, but a federal official, saying that their cooperation has, that they've cooperated with federal officials and the case is over, the trafficking investigation or prosecution has ended, they can get a green card. They can apply for a green card without waiting the full 3 years in T status. So it's a faster route to a green card. Finally, the final consideration, if you're trying to think between the two statuses, that I think is very important, is that the grounds of inadmissibility are different. The grounds are different. It's a much broader waiver of inadmissibility with a U than with a T. And the rules for when those grounds of inadmissibility can be waived are also different. And so you're going to look at the grounds of inadmissibility that your clients have if they're potentially eligible for both, and see where they're going to do better. So they're similar animals, they work in similar ways, but there are some key differences between the two kinds of immigration status, though you may, when you are working with a trafficking victim, have an option to pursue the U and T route, and you're going to want to look closely at the statute, look at your client situation, and see what's going to be the best avenue for that individual.
Well, thank you, Julie. And this concludes our webinar today. And as Sophia mentioned, it concludes the webinar series. We will have this seminar posted online, and you'll get an email with instructions probably within about a week when you can access the webinar. Next slide. There's some people we'd like to acknowledge. I want to thank the people here personally. I want to thank CUNY School of Professional Studies and Citizenship Now for giving me the opportunity to moderate this webinar series. It's been a pleasure, and I've learned a lot and worked with a lot of great experts in our field. And I want to thank everyone for joining us for the last couple of webinars, and we appreciate your time, and thank you so much. The webinar is now concluded, and thank you so much to Julie for a great presentation. Thank you.
Okay, Pat's not there. Okay. Where we were.